All right, everyone, I'm going to kind of bring everyone's attention back up here to the front. We've actually got something of an announcement from our friends at BMES, so would you like to take it away?
Everybody, I'm Jillian Rashcorn. I'm a senior in BME, and I just wanted to make an announcement about the BMES panel that we're doing on Wednesday. So raise your hand if you think you want to do BME. Raise your hand if you're not too sure, but possibly BME. Raise your hand if you're in this class for no reason you're not doing BME. Okay, exactly. So everyone is like thinking about BME. I know that there's lots of talk, everyone gets scared whether you want to do BME in the future with internships and co-ops and going abroad and everything like that. So I actually am organizing a panel of seniors to come and answer any questions you guys might have. There's a bunch of questions already set up, but any questions that you guys want to have and ask. So we're hosting this from 5 to 6 on Wednesday. It's in Chrysler 133, which is underneath the engineering advising office. And hope to see you guys out there. Wanted to make an announcement. Does anybody have any questions? Another thing is BMES is a great student organization. To learn more about BME, we have a bunch of industry events, a bunch of like med school events and stuff like that, which is a great thing for you guys to get involved with. And if you have any questions, a bunch of seniors, I'm not a scary person. If you guys have questions about BME, I'm always welcome to help. My number is up on that message on that board, and hope to see you guys there on Wednesday. If you guys have any questions, thank you.
All right, thank you. Round of applause for our announcement maker. There we go. Thank you very much. Yeah, definitely check that out if you've got an interest. I'm going to finish passing up just the rest of I'm going to finish passing up the rest of the homework, so you got about 5 minutes of an answer chamber here. Then we're going to be talking about legal considerations in biotechnology. Sound good? All right, great. Shreeman. Not okay. Tyler. There you are. Anita. Stephen? Can you get that way back to Stephen for me? Anaga? Anaga? No, Anaga. Michael? There you are. Can you get that back to Michael for me? Thank you. Nikhil? There you are. Can you get that way back to Nikhil for me? Matt? There you are. Can you get that way back to Matt for me? Thank you very much. Abby Reed. Natasha? I know I just saw it. There you are. Can you get that back to Natasha? Giselle? Right up front. Thank you. That'll teach you to sit up front, all right? Andrew? There you are. Can you get that back to Andrew? Azam? Oh, okay. Jack? Amalia? Okay. Can you get that back to? Thank you. Ryan Scott? There it is. Jason? There you are. Another one for you. Alec? No, Sosha, sorry. Thank you. Thank you. Sarah? Yeah, it's way back there, yeah. There is Sarah. Can you get that back to Sarah? Truman? There you are. Thank you. Parna? Oh, goodness, way back there. Alex. Thaddeus? Hamza? There you go. Okay, and then finally Samantha. Can you get that back to Hamza? And then can you get that back to Samantha? Way back there. If you don't have your homework yet, it's just because alphabetically you weren't here when it started, but I'll give it to you back at the halfway point. Everyone who just got their homework back, just kind of put that to one side. It does not matter for what we're doing right now. What we are going to be doing now is talking about a few brief considerations of biotechnology. There's a lot to know about biotechnological law. I mean, there are tons of law firms you should be familiar with. They are familiar with tons of different laws. Today, I'm just going to be introducing you to topics that I think are most relevant for engineers to know about. These aren't necessarily the most legally important, though they are. These are the most important towards the effects of what you as an engineer will be doing. Okay, so legal considerations. Usually what we're talking about in that case are trademarks, copyrights, and patents. Does anyone know what a trademark is? TM, what's that do for us? Oh yeah, and this is going to be quite a talky class, so you may as well get in the habit now. So, this particular class. No one knows what a trademark is? That is actually a neat summary of what each and every one of these are. That's fantastic. This is our thing. Don't use it without our permission. Trademarks in this case basically go towards logos and what a thing kind of looks like, a brand representation. The block M has a trademark. A copyright is kind of like a trademark, but for more than one word. You know, more than a few words. It's for lots of words. It's for things like poetry and you know, everything you're actually writing down as notes are automatically copyrighted and belong to you as its author. The United States of America grants you that. But you can also seek, you know, copyright protections. And let's see, notes here. There we go. And finally, patents. When I had asked you a question in homework, a lot of you had touched on gene patents and talked about just the right to, I don't know, buy, sell, have, own certain kinds of information. What a patent is an exclusive legal right to an idea, to an invention specifically. And we're going to be talking a lot about those for now. So I'm going to not really be focusing too much in any way on copyrights and trademarks because we're going to leave that to the marketing folks. For us engineers, patents are our bread and butter. So where do we actually get these rights from? You know, not to get into discussions of natural rights or anything, but where does patent rights come from in the United States? The government where? Patent law, where does that come from? Legislature, laws do tend to come from there, but this one actually doesn't. It's okay. Supreme Courts does help, but they don't give us laws, they interpret laws. It actually comes from the Constitution. This is a constitutional right. And more specifically, you know, you look at this is the actual Constitution, it's kind of hard to read. Right there is exactly where we get the right to patent. And what it says is it grants to the Congress, to the legislature, Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This is all the Founding Fathers had to say about patent rights. But it was actually so important. It's an Article 1 right. This is a big deal. Article 1 rights matter. And I assume you've taken some kind of civics class. This is Section 8, where the powers of Congress are enumerated, and it's Clause 8. This actually comes before the Congress's power to declare war. So our founders thought it was very important that we ought to have a patent system of some sort. We ought to protect the ideas and inventions of our fellow citizens. Any questions to that point? That's okay, we're just getting started. So some of you had somewhat touched on where patent laws come from. There are exactly three sources of patent law. The first is the United States Code. This is particularly Section 35 of the United States Code. This is a statutory requirement for patents. Statutory means there are literally statutes. There are rules governing what a patent is, how it works, what it looks like, who interprets them. There are rules. So the statutes say that there should be some governing body for this. There should be a USPTO. But The Code of Federal Regulations, the CFR, 37 CFR, actually comes up with the rules for governing the operation of the United States Patent and Trademark Office. So when I keep saying USPTO, that's the United States Patent and Trademark Office. And this is where all patents in America get decided, every last one of them. And finally, as mentioned by one of our colleagues, case law matters. The Supreme Court does matter in this case, but only because we in America have a common law system where the decisions in one court affect the decisions in other courts, where the actual interpretation of laws builds on itself. It's not all just some piece of paper. So those are the three things. You can get it from statutes, from rules, and from case law. And I do recognize many of you are going to be bored to tears about this. You are engineers, you are not lawyers. I'm sorry to teach you even this minimal amount. There are at least 5 requirements. There's a minimum of 5 requirements to getting a patent. And these are all, there are rules for every single one of these. We're just going to keep going, or be going back to the United States Code, the actual laws of America. 35 U.S.C. 101. A patent, this just outlines statutory subject matter. What can and cannot be patented. When we started, when many of you started looking into the gene patents in the Myriad Genetics case, they said it was a product of nature and therefore could not be patented. That rule comes from 101, section 101 of 35 U.S.C. We'll get into that in a bit. It also must be enabled. You have to have some description of your invention. It has to have some bit of definiteness to it. It has to be a thing that's real. You have to have shown novelty. And that means it could not have been anticipated by someone else. And finally, it needs to be non-obvious. So even if no one else had your idea, you can't simply take one person's idea, some other person's idea, and combine them and think that you've invented something. Not according to the United States government. So these are the sort of key terms that you really ought to be aware of in this space. When we start talking about patents, we care about the subject matter, the enablement of the invention, the definiteness of the invention, its novelty, and its non-obviousness. You can, when you're applying for a patent, be rejected on any one of those 5 things. Okay, so now let's actually really look at these things. So section 101 has basically this listed out. This is the preamble to section 101, and it states as follows. I apologize to read it to you, but you ought to be familiar with these laws. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefor, subject to conditions and requirements of this title. So what can we patent? Ah, darn it, what can we patent?
Like an actual physical, like invention, like it says machine, so create like a thing of technology or something.
A thing of technology, yeah, an actual machine. This little desk that goes up and down probably has a patent. Yeah, I didn't know it went up either. The projector, that's a machine. What else can we patent? Processes. How does that get made? How does this get made? Exactly right. We will patent the process of making something. Methods, that's kind of that is like a process, but a method claim is slightly different. It's actually a patent on how you use something. So you can actually patent the way something is used.
Certain materials?
Certain materials, yeah. That's exactly right. I don't have a quick, pithy answer. Oh yeah, it's a composition of matter. That's exactly right. Yeah, you can come up with new drugs. You can come up with new kinds of steel. All of those can be patented.
Like if you have to ask into like it says negative beta improvement, like an altered version, that's the equivalent to the improvement upon.
Exactly right. If I put cool wheels on it and could drive it around or something, that could be an improvement that I could patent. Perhaps it's obvious that I couldn't. But yeah, so you've actually nailed every single one of them. It can be a process or a method or a use. It can be a machine or an apparatus. It's some actual thing you can touch and hold, or maybe it can be held, or it's got some physical, physicality to it. You can also patent compositions of matter. So this is where, when we started talking about gene patents, does that count? Do artificially made genes count as new compositions of matter? In fact, do genes as themselves described count as compositions of matter? And finally, any improvement thereon, you can get a patent on. Not any improvement, but assuming it's not obvious, and assuming no one else has ever thought of it, yeah, you can get a patent on it. So this is what an actual patent looks like. This is the actual patent for the actual myriad genetics case, which you actually read. It looks a little bit like this. This is known as a utility patent. It's got a few key parts to it. We don't really need, unfortunately in this class we won't go too much into this, but really, try to learn this. It'll always have a title, it'll have an abstract, it'll have inventors, assignees, it'll have a filed on date, you'll have some fields of use. It will give you some sort of idea of where this patent's lineage. This tells you that it's a continuation in part of another patent, which can be a condition, it can be abandoned, it can be, you don't need to worry about all that, but all this to say, this is a utility patent. This is for a thing. And this is the most common type of patent. When you go out and start looking at patents, this is what you're going to be looking at. You're going to be looking at utility patents. There are also design patents. Now, design patents are very, very specific. Where a utility patent can be for any old thing, a design patent is literally, just literally, the way something looks. So this patent for the iPhone is a patent on the way the iPhone works, but not anything else about it. Not how it's made, not what it's made of. In fact, this is going to, all design patents have a single claim. That claim will always read just about approximately this. The ornamental, so I claim the ornamental design of X as shown and described. That's it. So you need to have very good pictures. They need to follow certain rules. Those are all through statutory convention. That's all a design patent does. You don't need to get a design patent. Go get utility patents. And finally, one that is going to be important for some people in biotechnology, but we're kind of not going to focus too much on it because we're more of a medical bent here, but there's actually plant patents, which is fun and hard to say. Plant patents protect newly developed strains of plants. So you come up with a new kind of corn, new kind of carrot, you can go and get protection of that. And so the claim will usually be something like a new variety of something, some tree, that has been described in this specification. Yes?
Can we get a patent on newly developed strains of diseases?
Huh. I think so. Well, so it depends what you mean by disease. So her question was, can you get a patent on a newly designed form of a disease? If that disease is, I don't know, like low blood pressure, you probably can, right? Because that's more of a systemic thing. If, however, you're thinking, oh, I came up with a new kind of influenza, and I just designed this virus, yeah, you can actually patent organisms. It's a brave new world. Well, we're going to be talking about that here in about 10 minutes. So, yeah, keep that. Is that ethical? Is that something we ought to do? Should we be allowed to patent organisms or their products? We've actually got assembled up front here a panel of people who will engage you on these topics. Okay, a little bit, much to their chagrin. Okay, so now looking a little bit more into this, but that's a great question. Looking a little bit more into this, a patent must be enabled. And enablement basically means in the specification, in the thing where you're talking about this, you need a written description. That written description needs to describe the manner and process of making it and or of using it. You need to tell me enough information. And and it needs to be in terms that are full, concise, and exact enough so that a person of skill in the art can make and use it. And that you're going to hear over and over and over again. A person of skill in the art has to be able to interpret it. If they cannot, you cannot get a patent on it. Crazy, right? So you need to be, all of this needs to be written at a level that you and your peers can understand. Okay, now that's pretty clear. Any questions up to this point? Okay. It's got to be definite. I think we all have a pretty good sense of that. We basically need one or more claims that particularly point out and distinctly claim subject matter which the applicant regards as their invention. And just to highlight what's important there, you need to particularly point out what is important and distinctly claim it as new subject matter. You need to say, no one else has ever done this, and therefore I claim it. That's the claim of definiteness. It's very rare for you to be rejected. Well, it happens through the patent office like that. Okay, and it's got to be novel. What we mean by novel is it cannot be anticipated. And an invention lacks novelty. It is anticipated if and only if each and every single element set forth in the claimed invention, is expressed entirely in a single prior art reference. If there's another patent out there, or another scientific journal, or a presentation, or an infomercial, or some public record that someone else had your idea exactly, it lacks novelty. This is a hard thing to get over. And the reference, that prior art must teach every aspect of the claimed invention. Yes?
Does that go down to like color?
Yes, though usually they wouldn't claim color. And color is more of an ornamental design. This is a good point. There are certain things that really don't confer to you any added advantage. So say you said, I claim the invention X, some stapler. And then you also said X can be read in a dependent claim. Well, that doesn't really give you too much, because the broader claim, stapler, is more powerful than stapler plus read. And then someone couldn't just go and say, well, I've got your stapler and I'm going to paint it red, therefore it's a new invention. Well, no, that's obvious.
Right.
You would actually fail the next test, which is obviousness. It has to be a non-obvious addition. This is section 103. This is the bread and butter of your federal government's tax dollars in regard to the USPTO in arguing with other people. Was an invention obvious or not? An invention must be more than a mere modification of prior art. This is the rule by which they go on. So unlike a section 102, which is about definiteness, or novelty rather, section 103 can actually be combined. Multiple forms of art can be combined. The most I've ever seen in one rejection is 13 different prior arts, all being combined and said, oh, if you just took these 13 other patents and smashed them all together, it would have been obvious to come up with your invention. That's crazy. This is the world you live in. So we've actually gotten pretty far without having a fundamental conversation. What is a patent?
Declaration of ownership of information.
Declaration of ownership of information. That's really pithy. I like it. Yeah. Yeah, I mean, it's totally right. What else is it? What are some features, factors, facets of it?
Well, they also feel like the physical paper itself.
It's a physical, yeah, it's just a piece of paper that the government filed somewhere. Yeah, that's entirely true. It can allow you to sue or protect yourself. Entirely right. Great answer for one and all. A patent is a property right, just like you said. And more specifically, it gives you the right to exclude others from making, using, selling, offering for sale, importing, or in any way profiting from your invention. It's basically the same right that you have for, I don't know, a bicycle that you have, or a car, or a house. People are not allowed to use it without your permission. So in this case, we consider it a property right. No one is allowed to use your invention without your permission. It's also a term-limited right. I'll save you a lot of the history and a lot of the change, but at this point, 20 years from the date you file your non-provisional patent is how long you have for protection. As soon as you file your non-provisional patent, which we'll get into, as soon as you file that, 20 years from that day, your protection for that invention will be gone. There's a few extenuating circumstances. But what that means is afterwards, it's going to be in the public domain. Everyone's going to know exactly how the sausage gets made. And that's the bargain that we have conferred to you. We're basically giving you a monopoly, an exclusive right to this thing, in exchange for you telling us exactly how it's done. And it's a territorial right. A U.S. patent does not matter in Mexico. A U.S. patent does not matter in China. Chinese patents do not matter in America. There is no world patent. There's a World Patent Organization, but that doesn't help. I mean, it does help. It's very good. What I meant was, it doesn't give you one big thing. I have invented this, therefore I've covered it everywhere. It's all territorial. It's all country-based. Any questions on that? I know that's a lot to kind of take in. Yeah.
So, could someone in, I don't know, say China, and someone in the U.S. hold two different patents for like a similar invention?
So it would be hard for that to happen if you have the same invention, because one would probably count as a prior art for the other. So if someone invents something in China, and 10 years later you're like, oh, we ought to get a patent for it here in America. Well, it still exists in the record. And so you would not be able to get it because it's now obvious, or it lacks novelty. But if two entered at the same time, yeah, a lot of things can happen. A lot of hard decisions have to be made. In fact, with CRISPR-Cas9, two teams in America both came up with the idea pretty much days apart and filed it. And then one had a patent that issued first, but one had a patent that was filed first. Who invented it? It's hard.
So what about if the patent starts out in the U.S., but then somebody else just take that patent and file it in the country with less strict laws about?
Yes, they can.
And it just,
That happens. But what that means is, so say you go to some sketchy country, and I won't list sketchy patent countries, but they are out there. But America's very good about it. What that means is you wouldn't actually be able to sell that product in America, or anywhere that wants to, and there's lots of protection. So China will recognize, say, America's patents in a dispute sometimes. It is very much a sometimes proposition. But yes, someone could go to a sketchy country, get a patent for it there, but what's that really give them? It means they now have a patent, the exclusive right to that idea in a sketchy country, which might not have a large market or any need for your brand new heart device, artificial heart. So, but it still protects you in America. Yes.
Isn't there technically international patent that it's really hard to market?
There's a what?
Like an international patent that it's really hard to market for.
So what there is, there's a thing known as the Patent Cooperation Treaty, the PCT, and this established the World Information or Intellectual Property Organization, WIPO. Yes, you can file an international patent application, but when it gets prosecuted, when it gets turned into an actual patent, those are all national phases. So yeah, you can file once, and anyone that's signed on to this treaty, it makes it cheaper to now do the national phase a bunch of different places. There's not one international patent. Good question. One last one, and then we'll move on.
Isn't there some way to avoid the term limit, like how Disney has?
That's on copyrights. Yes, and that's unfortunate. What Nighty is pointing out is that a lot of people, especially big corporations, kind of get around a lot of the rules I just told you about, especially Disney, mega corporations that have vested have a corporate interest in the protection of, say, copyright. Copyright law is terrible, if you have not realized it. Patent law, it's not that easy. Because eventually everyone's just going to know how to make it. And after 20 years, they're going to start doing it. All right. This is an important thing. And this is, if you get nothing else out of this lecture, please get this. Because a lot of people misunderstand what patents are. A patent is a sword or it is a shield. By a sword, what we mean is a patent can be used to stop someone from profiting from your invention. You can sue them if they profit. So if someone has your idea and they're making money off of a patent you had, you can go to court and sue them. You can't physically restrain them or anything, but you can sue them and get your money back. Or it can be a shield. Someone wants to sue you. You can say, no, I had this idea. These are literally the only two ways patents can be used. You had a question.
Yeah, what if I just essentially made someone's, someone patented a product and I made it, but just gave it away, didn't make any profit off of it?
You can't, well, how are you giving it away?
Literally, like I'm walking down Main Street.
So that would be considered, and I think in law it's considered an offer of sale. Even if you're offering it for $0, you're basically...
What if I throw it at them?
Well, now you've got assault. But I suppose the nugget of your question is a good one, is can you make something, and if you don't profit on it, can someone still sue you? The answer is no. So you can actually make patented stuff. As long as you aren't trying to give it away, if you're not trying to import it, if you're not trying to sell it or profit from it, yeah, you can do that. That's what I mean. A patent is just a sword and a shield in a court of law. Everywhere else, it's just a piece of paper.
So, like, if you just made it for yourself and didn't, like, share with anyone, it was just for you, doesn't do anything for profit, it's...
How would they know?
So what's to stop individuals or companies from just issuing a ridiculous number of patents on any number of things so that in the event that someone else tries to do something, even though they have no interest in pursuing any of the patents?
Welcome to patent trolls. It's hard. Yeah, that's one of the problems of the system. And we'll talk about it here in a bit, but that's a great point. Like, what's to stop me from just sending out a million, billion different patent ideas? Well, the problem is it costs a lot of money. It's about $5,000 to maybe $100,000 to get a patent prosecuted. So if you want to start doing that a lot, you have to have a lot of money to begin with. Okay, so why get a patent? These are pretty much all the reasons. To get a patent, it'll just help you enter a market. It'll help exclude people from coming into a market. It serves as a marketing tool. Basically, you can say patent pending or new patented design. And it allows you to sell or license just like you would any other product. Any other property of yours can be sold or licensed. This is why you get a patent. And if you can't tell, a lot of these are market-oriented. This is about making money, about sustaining businesses. It's not about depriving people of the means of making things. It's about ensuring that for your innovation, you kind of get a little bit of a respite from competition from your market peers. Apparently I didn't give you that one. I apologize. So yes, this is why you get a patent. Not too many other reasons. Yes?
Would you say that after like 20 years time of you basically having, like you said, a monopoly on your product or your idea, would you say then it's like hard for others to enter? Like, is it?
Yeah. It can be. Yeah, if you've got a 20-year head start on a whole industry on how to make something, it's going to be hard to catch up. That's also kind of the point. Oh. So who can file a patent? In America, anyone from anywhere can do it. Someone in China can. Someone in Antarctica can. Actually, I don't know about Antarctica. I really don't know how sovereignty applies there, but certainly someone from Canada. Anyone from anywhere. With one exception. Well, I think there's the one big exception is that officers and employees of the Patent and Trademark Office cannot get a patent. It's the life they chose, but they know the rules too well, they know how to play the game, they can really abuse the system. And one important word to know, the phrase that's going to pay also today, is assignee. A lot of people also say assignee. Either is fine. Assignee is what a lot of people say. So get it out of your system now. But an assignee is an entity, a person, a company to whom an inventor has to assign their rights. So when you go work for a company, they will be your assignee. So it won't always be you who owns a patent, even if you're an inventor. You might come up with an idea when you're at Medtronic. Medtronic is the assignee, the assignee. Okay, how does one get a patent? Same way you do anything. You apply for it. And when you apply for a patent, typically the way you're going to start is with a thing called a provisional application. You either draft it or you get some attorneys or patent agents to draft it for you. You draft a provisional application. A provisional application is just a stake in the ground. It's saying, I invented this by this date for this reason. It's a low-cost way to ensure that you have captured your filing date or your priority date. You don't need to necessarily get all of that, but provisional application starts the process. It's the low-cost way of doing it. All right, I'm going to go on to the next one. Anyone object? No objections. Seeing none, the motion passes. Then, after about a year, after 12 months, you have to, within a 12-month window, you have to submit a non-provisional application. A non-provisional application is one that the United States Patent and Trademark Office is actually going to look at. Your provisional, they're never going to look at. They don't care what you wrote on it. They will only care if it ever gets litigated later. But otherwise, they don't care. They're never going to look at it, no matter what you said inside of it, which allows some people to do what's called a cover sheet provisional, where you basically write your name on a piece of paper, staple it to the application form, send it in. That's it. That's all you have to do. Fun, right? Okay, so a non-provisional application will actually be reviewed. And so that application has to include a few things. First, you need to include what's called a utility application transmittal form. It's fun to know these things, right? This is just basically say, I want to have a patent, please. The second thing you have to do, definitely important, is a fee transmittal form. The USPTO will not be looking at this for free. It will cost you about $1,000-ish currently to get the USPTO to even look at your application. So you have to pay them money to review your application. The application data sheet, also known as the ADS, is going to sort of fill in all the important boxes. What's the title? What's the inventor's name? Who's the assignee? What's the filing date? You definitely need all that information. You need a specification, and the specification is the thing that's going to matter to you as engineers, because the specifications actually includes all the stuff that we care about: abstract, title, cross-references, background of the invention, summary of the invention, brief descriptions of the drawing, detailed description, and claims. Each and every one of those is a necessary component of a utility patent application. If you lack any of them, except for drawings, your application will not be granted. Drawings, like I said, if necessary, you need to have those. They need to conform certain standards. And you need what's called an executed oath or declaration of inventorship. This is when the people who are actually claiming themselves to be inventors of this product sign a piece of paper saying that I invented this. If you lie on that, that's a big deal. Don't do that. Then, now that it's not confusing, all this then has to be examined by a patent examiner. But that should be enough for you to kind of go on. So I'm going to just give 3 parting words, and then we're actually going to kind of try an activity here. General notes on patents. 3 things. 3 things that matter that you will have never learned in any of your other classes, so it's important that you learn it now. A patent application is not a granted patent. Applications and granted patents are different things. A patent application means nothing. Well, it means something, but you can't be sued. If someone has a patent application that has your exact idea in it, they can't sue you. They can only sue you with a patent. A patent is what matters, not the application. You cannot be sued or sue with an expired patent. So if something's in the public domain, you can't use it to sue someone. You can use it to your heart's content to do anything else. And then your application almost always, certainly, 99% of the time, is always going to be rejected the first time. And that's okay. This is part of the process. Patent examiners live for nothing more than to say your idea is not great. Actually, they want you to get the invention. They just have to be real pains in the ass to make that happen. But don't fear that when that happens that first time. Any questions to this point? Yes?
So if it gets rejected, do you just submit the exact same thing?
Nope. Now you argue back and forth. Or you pay basically an attorney to say, you are full of it, patent examiner. We deserve this invention to be granted. Yeah, you just argue.
During that process, or?
You can only edit the claims. You cannot edit anything else.
So, say you like created a company based off an invention, and then you sold like 30% equity to investors. Do they have a right to that patent then? Like,
It depends if that was part of the agreement. Yeah, it can be. Usually that will just be specified in whatever contract you're doing. But yeah, usually. Yes?
Do you have any patents?
Yes. I was really surprised by this. You should really learn to brown nose your professors a bit more. No one had actually said the law firm I personally worked for on the exam. Had you said Wilson, Sonsini, Goodrich, and Rosati, you would have gotten like a +5, you know, just out of nowhere. So yes, I've been on both sides of this. I have pushed inventions through, and I have myself argued with the federal government for money. So. Yes?
How long is your patent normally pending for?
It depends on the kind of patent. So some things can be pending for as long as 7+ years. You know, in the actual examination process, usually on the order of about 3 to 5 is typical. But especially in biotechnology, there really isn't much typical. There's just huge variation. Sometimes, so if you come up with like a new drug, it's usually, you know, it can be pretty easy. It's like, oh, no one's ever done this. Boom, granted. If it's like close to another drug, it can be hard. Yes, one last question, then we're going to... This is why you have to stagger a lot of these things. Yeah, this is where you need to consider the importance of all of this. Yeah? Okay, what we're going to do now, I've actually got 8 of your peers up here, and actually can I convince all of you to sort of sit on this side of it? And what we're just going to do now is something pretty weird. No one has ever tried this. I don't know if it'll work. I have no idea. But you all just talked about gene patents and whether or not things should be biologically relevant or whatnot. A few of these people had some pretty good answers. Actually, you all had pretty great answers. But now I just kind of want to open it up to all of you. Let this just be the first question. Should we be allowed to patent genes? No wrong answers. You all just talk. And people up front, you obviously can talk whenever you want. You all had plenty to say on your homeworks. What's that?
Why are they turned around?
Because these are the people you're going to be talking to. I'm not here anymore. You're all debating or discussing. Abby, what do you think?
Oh, fine. Okay, I think that if they are naturally occurring, you should not be allowed to patent them because you didn't invent anything. Finding it doesn't mean that you've done anything really significant. It'd be like patenting a chemical element that is found naturally on the earth. It doesn't make any sense. But if you make it in the lab, it's not naturally occurring, then I think they should be patentable.
Anyone agree, disagree? Oh, you don't. You're all talking to one another now.
There's a gene mutation that's only makes whatever you're making natural. Is that void patent? So you're saying that anything that's made in a lab, like any organism or something that's made in a lab, if that is not found in nature, then you patent it? What if we do later in time find it in nature? Because there's still things that we don't 100% know about. You know? So does that void the patent?
Thoughts from the audience? You're all part of this.
Please help us.
I mean, it's kind of weird because at the time of the patent, it was seen as a novel idea that hadn't happened. We wouldn't know about it. It is very awkward because at the time of the patent being issued, yes, it was novel. Yes, it was something that was invented. It wasn't as far as we knew. Discovering it later, I suppose, like if it were like just suddenly, like if it had been around, like would it depend basically on if that thing had been around or if just in the wild there was just suddenly a random mutation that happened that caused it, like just like, oh, we got this new gene in the rat and then like suddenly like in the wild there just happens to they find like a rat that happens to have those same genes that was in the wild, like
You can sue that rat.
would you get like?
Not selling it, so.
Very
It
good.
kind of also has to do with the whole not obvious thing. Because if you invent something that's not obvious, and then later in the future you find something that makes it obvious, would it still be like worthy as a patent or not?
I think if the patent is still valid, it should be void, because now that that thing is naturally occurring, people should be able to use it. So.
I kind of agree with that. You could, I mean, I guess I don't know the law, but like you could theoretically have a law that said if this is found to be naturally occurring, like by applying for a patent, you like give up your like forfeit your right to the patent if it's found in nature.
I think like if they got voided, like the patent of the actual thing got voided, like you still have the rights to like the mechanism that you use to like alter something into that thing, like the process like they use to make it. That should still be.
Wouldn't those be separate patents though? Like if there was a process going into creating something?
Yeah, like you had like two patents like for the thing and for like.
And you can
Yeah,
actually
so-
claim both in the same patent. You can
Okay.
claim both methods. You can claim utility, methods, processes, all in the same patent.
So then I would think that the section that would be voided of the patent would only be the information itself. The process should be still patentable.
As long as like the process isn't like the same exact process that like, leads to the like, mutated thing in the wild.
Here's a curveball for all of you. I think actually every single one of you said naturally occurring genes should not be patented. But there's no such thing as a naturally occurring gene, right? It's a construct we all make up. We take a DNA, we convert it into an mRNA, we splice out a bunch of introns, and then that little thing makes the protein of interest. That's the gene that we're talking about. But that doesn't occur anywhere naturally, not in DNA. It occurs in mRNA. So can we get a patent on the DNA? Why or why not?
I disagree. It's not a natural process though, because if it's still made within the body.
Yeah, because DNA and mRNA are both, like, although they may be different, you're kind of distinguishing them, like the actual like expression of the gene and the gene. Yeah, it's two different things, but like even if you, let's say, own a part of the DNA, like you're basically then owning a part of like every human or like whatever organism you're looking at on Earth. So think about like if you got a patent for that, do you then own a part of whoever that thing or gene or whatever is in? That's kind of that would be kind of like.
I'm just thinking like, I mean, can we redefine like naturally occurring to like not consciously like man-made? Like would naturally occurring mean like just not made like in a lab or like by man? Because like because the proteins they're made in the cell, that and cells like all their process would be considered natural, wouldn't they? Because cells just naturally exist in the world. They're in the world, they make these elements, that's just how they do. They've always been doing that, so you can't really change that or stop them from doing it. So the cell just naturally makes it. You can't really say it's like, you would say that it is naturally occurring because it just is made, it is.
But what if you physically put together some DNA strand that's not found in nature? So like you take a bunch of nucleotides and you piece them all together, come up with some DNA strand that isn't found in some organism, it is completely original, would you patent it or not?
I would assume that would be yes, but like if you're just trying to patent something that already does exist in nature, you can't really patent that. Like if it's
For your idea, wouldn't you have to prove that not one person on the planet has that?
or not
That's
one
it.
thing.
But like,
Not one
but if
person.
someone were to tell us something that is completely original though, like could that be patented even if there's a chance that it could be made?
Would that be like obvious though, because you can say like, beyond like the A species of genes. You can say like it's obvious, so like you can somehow like combine them into the one that you just made. It's like,
No, but like you're, I don't know.
Yes,
Because
I don't
the
know.
only reason you care about the DNA.
You all can be all too.
Yeah. I'm still trying to wrap my mind around like what Dr. King's talking about. Like,
What I mean, in case no one quite got that, is the argument that myriad genetics made is that we've got ourselves a piece of DNA. And we think there's some sequence in that DNA that matters. You know, we're basically saying, okay, give us these. We want this sequence that would describe going from A, B, C, D. We just want DNA that corresponds to A, B, C, and D. Their argument is A, B, C, and D don't naturally occur, or they aren't occurring in the way that we're claiming, which is A, B, C, D. They occur with A, B, exon, C, D. And that it's not in any way easy to figure out where B and C actually connect. Because the only way you can do that is with lots of testing and lots of trial and error. You have to do a lot of indenting. And therefore, we should be allowed to claim this. Now, what was claimed by the American Association of Molecular Pathologists is that, no, the mRNA has your A, B, C, D, and therefore you shouldn't be able to get the DNA, the actual DNA patent. What do you make of that?
Well, I mean, that kind of makes sense because mRNA really create ABCD because reverse transcriptase makes cDNA like that. So they're not really inventing, you're just simply putting the mRNA through a reader, I guess.
True.
It's kind of in really, really simple terms, but I think that in like the legal ownership of this kind of information, I think it's like it makes sense for artificially synthesized genes or like things that require experimentation and manipulation to be to get a patent. But if it's like something that like, because that way like in those cases there are people that did the research and people that like did the manipulation and those people get credit for it. But if it's something that just occurs like that, you can't really like say who made that because it's like already there.
But doesn't all DNA have to be manipulated to be like even looked at, like at all? Like period.
So there was no novel process or anything that went into it. That's why it shouldn't be patentable.
What about like, let's say you can patent like the part of the DNA or whatever. Then does that mean that every single person in which it like happens or exists, are they violating your patent? Then this is like the other way around. That like is it's not for profit, but like I don't know, like
if one requires DNA to make profit, then couldn't the fact that they are a living being with this DNA isn't that a prerequisite for them to make further profit on anything else? And so they are.
It looks like you got a center over there.
It would, because I mean, to say like if you have this DNA in you to make you alive, so you're making profit off that, are you making profit off of the DNA because you're selling the DNA, which is violating the patent, or are you just having something? Like, say I make an iPhone which has a patent, and I use it myself, and I call a business, and I make a business deal while I'm on my iPhone. Did I make a profit from the iPhone, or did I make a profit from the business deal?
I mean, I'm not super familiar with patent law, so I don't know how that would pan out. but I think in essence the question boils down to if you make profit off like using the patented information, is that equivalent, different, or like to actually selling the information itself?
Yeah.
I feel like that's why you have to have it where anything naturally occurring can't be patentable. So you can't just be like at fault just for existing. Yeah, and the key thing with that like DNA mRNA thing is maybe if you look at it through the light of like the information contained, you can't patent the DNA because there's a naturally occurring thing that has the same exact information. It's in a different form, but it's in the same information. So if you're not getting anything extra from having it in DNA, the DNA itself doesn't do anything. It just goes back to mRNA.
Here's the thing, just to blow your mind, not that it matters. If you were to take pi, the repeating digits of pi, convert that all to binary, all that actually contains every single play that was ever written, every work of art, just all that information, because it's just randomly zeros and ones. It goes on for infinity. All information is actually contained right there. Should we just get rid of intellectual property all at once?
That's actually exactly what I was thinking about. How you're talking about like since
all the nucleotides like are all known, then what about like computer code? So can you not like patent computer code because it's all ones and zeros, and ones and zeros are obvious?
But it's a particular organization of ones and zeros that relays a type of information.
Yeah. I was just
Yeah, you all should just talk. Yeah.
Could you like instead of patenting like the DNA or RNA itself, like could you get a patent for the right to like experiment or research with it?
I mean, that's essentially what, you don't get a patent for that. You get a patent on the material, and you can exclude others from researching it, which is what Myriad did, like jerks. And yeah, go. Yeah, you can still talk.
The Myriad was also sued by the ACLU. I don't know if this is
It's the same case.
Okay.
Yeah.
I don't know why the defendant is different, or the plaintiff is different in this case. Because the other one was the ACLU and not the biology one. Anyways, they mentioned another company that had actually gotten a gene patent, and the company went bankrupt. And what they would do just to make money was like anytime that anyone tried to use that gene in any kind of research, they would just sue them. And like they'd win because they had the patent, but like they're not doing anything with that, so they just had a monopoly over it, and people were dying because they couldn't do the research on a disease. That's changed.
Why can't you use a patent in research instead of selling your research for profit?
So that's one of those very gray areas. You're right. That's actually how a lot of academic organizations get around that. They say, we're not profiting, we're offering this for free use, therefore don't worry about it. And that's true. To an extent, you can do it that way. The problem then becomes, well, what if that person comes up with a new technique, and then they file something with their Office of Tech Transfer? Well, now they've filed a patent, or basically acknowledge that they've created some IP, and that's where you get the murky area.
Wait, so does fair use also apply to patent law?
Yeah. Okay, one last bit of questions. We'll get about 5 minutes on this last topic, then I'll let you go for about 5 minutes, and we'll go over the midterms real quick. Actually, we might not have enough time for the midterms, so I might push that back, but you'll still get them back, so don't worry about that. But you would all, actually, a lot of you touched on HeLa, the HeLa cells, with good reason. What do you all make of that? Like, should we be allowed to take and use someone's biological information with or without their information? Should it be compulsory? Do people own their discarded tissues? What do you make?
I think the main issue here is anonymity. Should a person know that if someone gives consent for their material to be used by someone for research, should that researcher notify that person that this research, this product of research is as a result of what you gave me? So should people know that it was Henrietta Lacks? Should people know that it was her cells that they used?
I'd argue it's more important, like informed consent, the idea that you are entering into a sort of contract. If you give consent for people to use whatever it is that they're using, whatever tissue, or you are kind of assigning them, this is yours now. And it should be done in a way that it's informed. They're saying, this is what we will use it for, and only this. And they have to like lay out, like you will not have the right to it anymore. It is now mine. You are assigning it to me. It has to be done in a way that is not compulsory. I think you should be able to say, this is now yours and I'm giving it to you freely. This is not any kind of a trade. I'm giving it to you.
I think it's kind of really difficult to do that, even though it seems kind of like it seems like solid and ideal. But like in reality, like if you're just like, for example, like giving a blood donation, then usually they store it until they like give it to someone, right? Then if it passes like it's not exactly an exploration, but like there's like kind of. If you pass that, they usually send it off to like a research place sometimes, and then they do research with it, and then they could potentially like develop something and sell it or get profit off of it, right? But then because like when you in the beginning when you're giving the blood, the sole purpose is to like donate it to somebody, for them. Like the consent form only talks about the donation process, and it doesn't say anything about after. Like the consent form doesn't say anything about research.
So the way to fix that would be to add that into consent form.
Just adding it into consent form works because you'd be adding so many different things, like receipts for donation, if not donation, then used for research, not for research, so on and so forth. I feel like you're gonna give somebody your tissues, you should have the right to either say dispose of it when you're done or go crazy. Not in better terms, because I feel like the entire issue surrounding the Henrietta Lacks HeLa cells was that she didn't know that what was going on with her cells, and the guy in his lab who found out about the HeLa cells, he was literally just handing it off to different people. I feel like in this kind of like we should use it as like kind of like a landmark of like what not to do. Instead of like if we're ever taking any sort of samples from someone, we should give them the ability to say, yeah, here's my tissue. You can do with it what you will, or here's my tissue. When you're done with whatever analysis I consent it to doing, then just throw it away, or something like that.
But doesn't that kind of imply that like we all inherently like have patents on our own proteins?
It's not necessarily a patent. You can't sue them for the stuff that they make. You can't sue them for being like, I didn't say you could use my stuff like this. I told you that.
But isn't that what you do with the patents?
Well, but it's also a property right. That's what you would do with anything. If someone took your bike, you don't have a patent on your bike. You just own the bike.
But like once your cells leave your body, then is it still like technically yours? Like I agree with informed consent, like asking, can I extract, this component or these cells? And if they say yes, like does the consent have to go as far as that? Like after, let's say they say yes, like you can take my cells, like at that point after they're out, like do you still own them, or did you just give them out and they can do what they want with it after that? Like should you have to say, yeah, you can take it, but you can only do this and this and this with it? Because like once that actual natural part of your body leaves your body, is it still yours? Like do you like own every little part? Like if I drop, like I don't know, like you know what I'm saying? Because like
yeah, I struggle to see how people can get mad that their genetic material is used for something, because if they weren't doing anything in the first place, because that's like lending your neighbor like eggs and flour, and then they make a wedding cake and sell it to someone and you get mad. When in reality you weren't doing anything with that eggs and flour to begin with, so how are you going to take credit for the work that they did to make it into something valuable?
I think a dude in California did get mad about this. They talk about it in the last book. I can't remember what his name was. Washington? It was somewhere on the West Coast. I don't remember. But basically, he was like he gave his tissues for research, and they got some sort of breakthrough with it. And he was like, hey, I want some credit for this because it was my cells that you got this from.
I think you've got a colleague over here.
He lost the case.
He lost it?
I don't personally feel like you deserve compensation for what other people that gain from researching your DNA. Like we freely give our DNA away all the time. We think about it. Like the average human loses 100 hairs a day. We use dead skin cells every day, and we don't hear about it. Like
no one's using them. Like no one's going through my trash can getting my hair
I don't know.
But like, there's no difference if you lose a hair versus knowing you lost a hair. Like, you're still not doing anything with the lost hair.
You can't do anything to stop that. So
Right.
It's a natural process, and all of us usually respect that.
No, but it is
as a
different. If
law.
somebody's like, hey, can I have the hair from your hairbrush? Or hey, can I pull out some of your hair?
also it's not like the person that it was taken from, it wasn't their efforts or their research or their time and their money that went into actually making the discovery. Like I agree, like okay, people should have known these cells were taken from Henrietta Lacks, but like should she get compensation for like the actual breakthrough that was made? Like it wasn't her that did it. Like just because
I think it's just about compensation though. I don't think it's all like monetary. I think it's more like having like your the moral portion of it, because the ethics. Because
with the people surrounded monetary, that's why they were upset. So like I think that like monetary, like money does have to factor into it, because that's like at the end of the day what's really going on with this new design.
I know the Human Genome Project though. The Human Genome Project, it wasn't the genome of one person. Many different, like 50 or something different people donated their samples to the project, and even today nobody knows exactly whose genome it actually is, because it's like a combination of a bunch of people. don't know whose it is, nobody's able to lay a claim on it in a way. So if we didn't know that it was Henrietta Latz's cells, if she gave consent for the cells. If she didn't know that it was her cells that contributed to the whole research, then it wouldn't have been that big of an issue in a sense.
I feel like Henrietta Lacks is kind of a special case though, because instead of someone using her biological material to create some new technique or device or something, they were specifically selling her cells that they just replicated. So it's not like they were selling something they made with her cells, they were selling her cells.
So are they still her cells if they're not a part of her body?
I don't know.
Actually, on that, I mean, I know we can keep going for a long time, but we've actually blown through some of the. I hope you all continue to have these debates. Take about a 2-3 minute break. I'm going to start passing back your midterms. We're not going to go over the midterms, but I will have some parting thoughts. We'll go over the midterms next Monday. But yes, I'll start passing them back. But yes, please be back as soon as you can. Robert, don't go too far. There you go. Very good. Shreya? There you are. Megan? Megan? No Megan? Thank you. Megan? No Megan. Okay. Raina? Eliana? There you are. Yeah, it's just fine. Christina? Morgan? Darn. Kitty had that back to Morgan. Ashley, I just saw you. 90. Ryan Castellano, way back there. Kitty, I get that way back there. There you are. Alan, there you are. Can you get that back there, Alan? Thank you. Isaac, you way back there. I was like, the other one. Jenna's way back there. Easton, there you are.
A combination of Tylenol,
all right, Luca. Okay, I'll Bria. Justin. Leo. Can you get that back? Greg. Oh, there you are. Okay, yeah, you can. That'll make it easier. Thank you. Isabel. There you go. I got Danica. There we go. Kaylee.
You gotta go.
Christian. Anna. Parr. Anna Callis. I know I just saw. Okay, I'll get it to her later. Erica. There you are. Emily. There you are. Get that back. Kevin. Yeah. Bump. Yoon Jung. There you are. Nathan. There you are. Can you get that back steady for me? Annie. There you are. Daphne. You're all right in front of me. Marissa. Julian. Back there. Can you get that back for me? Maddie. Where's she? Oh, where was she? I'll trust you. Abby. That's the only wrong too. I am Mercibar. Mercibar. I'm there. Can you get that back? Freeman. Actually, these are before. You're right here. And Anna, yours is. Tyler.
I just said like the $12,000 per year is really small.
Free. Brett.
But it's like essentially what you said.
Thank you. Steven. There you are. Anna. Michael. Nikhil. Matt. Natasha.